Hello, everybody. This is Steve Yoder. Welcome to the last full week, week 6 in Legal Studies 457, 557 here in the spring of 2025 at the UAB Collat School of Business. Once again, we have a great deal of material to cover in this 7-week course. Last week's extra credit question was whether or not the corporate tax rate of 21%, which was set in 2017, was made permanent at that time, or like many other provisions of that law, was it set to expire on December 31, 2025? And the answer is that particular tax rate reduction was permanent, but everything's on the table. It's entirely possible that Congress will undo that in some way. We just don't know. Everything is very much in flux right now. The second exam has closed, and I will be posting the results later on today, Monday, the 21st of April. We look at the law of agency, first because it's one of the most common legal relationships that we have in any setting, but particularly in the workplace setting. It can help resolve a great many issues of exactly how a worker should be treated. For example, when it comes to the payment of Social Security taxes, if you are an independent contractor, like someone who works for FedEx Ground, you will find that FedEx Ground will pay none of your Social Security FICA taxes, whereas if you are a worker for UPS doing pretty much exactly the same job, UPS considers you an employee, and therefore it will pay half of your Social Security taxes. So it can be a very material issue. This issue of whether a worker is an independent contractor or an employee was very much in the news in California starting in 2019. Drivers got their way, and a law was passed then that said that companies like Uber and Lyft have to treat them like employees and, for example, pay half their Social Security tax. But in the very next year, California voters, which they're allowed to do out there, passed a proposition that sided with the companies and said, no, they really shouldn't be treated like employees. The California Supreme Court eventually sided with Uber and Lyft and against the drivers. So nobody really knows exactly what is the state of the law out there. When we look at the other laws that affect employees, which there are many, many people go back to the early part of the 20th century, and they point to the terrible fire that occurred in 1911 at a factory in Manhattan that killed a great many people because the employer had too many workers jammed in too small of a space, and they had nailed shut the doors for them to get out. And that really raised people's awareness that perhaps some changes had to be made. One of the bedrock principles around that time was that anyone could be fired for at any time and for any reason, even a bad reason. We'll be looking at that. But as laws began to get layered on the workplace, among the first laws were wage and hour laws, such as overtime provisions. Here's a case we'll be looking at. This is still very much in the news. That is, overtime is very much in the news. Exactly how much do you have to earn above so as to not be eligible for overtime? The amount has gone up and down, and suggestions have gone up and down, and we really don't know where President Trump is going to come out here. When it comes to overtime, can you simply ask your employees to waive their right to overtime? After all, if they say they will work for regular straight pay, is that okay? Watch this video. find the answer. The minimum wage was also set early on in the life of employment laws, and every year the minimum wages have been going up in many states, but not in Alabama. We are among the states where the federal minimum wage of just $7.25 still applies. Until about 2022, the laws that prevented young people below 16 years old from working, except in very narrow circumstances, were pretty strenuously enforced. Here's an example of a McDonald's franchisee who was fined for employing 14 and 15-year-olds, but the landscape began to shift. Look at this, March 2023, Arkansas makes it easier to employ children, not harder, easier. Florida here, this is just this month, passed a law that allows some 13-year-olds to work. In about 1990, skipping over some other laws that went into place, but in about 1990, we got the Family Medical Leave Act that requires that employees in larger companies get unpaid leave. That is a very important topic in today's workplace, in today's HR department. But throughout the 1920s and 30s, people began to lobby Congress for the idea that they basically needed the government's help to live in certain circumstances, including when they were retired. And Congress passed the Social Security Act and Medicare in the 1960s, and we all, until today, perhaps, have taken these very much for granted. Social Security is funded by FICA. We talked about that a little bit earlier as to the fact that employees get half their FICA tax paid by the employer, but independent contractors, such as at FedEx Ground, do not. The Affordable Care Act protects us when we do not have Medicare insurance and we are low income. That law was extremely controversial, was attacked several times. Today it is tested on the CPA exam, so you can expect to get a question on that, and this is a pretty good summary that I put up here and that we'll be covering. Among other things, the Affordable Care Act requires that employers who do provide health insurance for their employees do certain things, including providing this form to employees every year. Many of you would have gotten this. The concept of privacy rose in the 1990s and protects particularly our health information, and this too is now covered in the new CPA exam. It's covered in the Information Security and Controls portion of the exam. Immigration law is commonly regarded as broken and very much in need of a fix. Everyone's aware of the controversies that are going on now. It is the case that employers have to use a system to prove that their new employees are here legally. Unions. We have gone back and forth in this country, either in favor of the formation of labor unions to represent workers or against. Some laws have passed so-called right-to-work laws. I'm going to expect that all of you know that concept. There will be one or more questions on your third exam on this topic. Some states call these laws right-to-work laws. It's really another way to describe them is anti-union laws. You can have a union, but they're generally more difficult to establish and maintain in a state that has a right to work law. Interestingly, Michigan, which you would think with all the automobile manufacturers there would be a strong union state, They passed a right to work law, but then they have very recently repealed that. The process of creating a union is highly regulated. Many of you who live in Alabama would be aware that most unionization votes at the automobile manufacturers, such as Mercedes in Tuscaloosa or the Amazon warehouse in Birmingham, those efforts have actually failed. Starbucks has been very much in the middle of unionization fights. Look at what Starbucks did in 2023, was found to have done in 2023. And the question was whether these are, quote, unfair labor practices or not. Here's another example of a state legislature trying to make it more difficult for workers to establish unions. They think by doing that employers such as Hyundai will be more likely to put a plant there. For example, in Georgia, it did not become law. The unions wanted to make it very easy to vote in a labor union, and the Alabama legislature, it was not signed by the governor, passed a law that said, no, we want secret ballots. The thought being that if you have a secret ballot, that workers would be more likely to vote against the union. Here's an example of a success for a union in Tennessee. The union was recognized at the Volkswagen plant there. Alabama is in on the action too. Alabama legislature suggested, I don't even think it got to the end of the process, a law that would block any state incentives for companies that voluntarily recognize unions. Employment discrimination, a very, very important topic right now. In 1964, a very broad law that was protected people against discrimination against certain things that are, you could say, beyond their control. Look at the bold-faced top items here. Race, sex, color, religion, and national origin are protected classes. We'll be looking at race discrimination. This is an action brought against the big turkey processor Cargill. Religious discrimination, gender discrimination. There are two types, differentiating on the basis of gender. Sexual harassment is also a form of discrimination based on sex, and we'll be looking at both what is and is not considered sexual harassment. The fact is that most things will be. When in doubt, you should assume that something that seems just like playful joking is, in fact, sexual harassment. These are myths that you should not believe. We are also protected against discrimination based on our age. Here's an example in your textbook that will illustrate that. We are protected since the 1990s against discrimination based on a disability that we might have, and moreover, employers are required to provide reasonable accommodations to those who are disabled. The topic of affirmative action, people rarely use that term anymore, but that's what is very much at issue right now in the United States. The idea that someone of African American descent could be preferred in hiring is not the case anymore. That's the classic definition of affirmative action. It was actually tested as early as 1978, and this guy says he did not get into medical school then because he was white and African American applicants were favored, and he actually won that case on the grounds that the Equal Protection Clause of the Constitution says that everybody has to be treated equally, including him, a very, very white man. Here's your extra credit opportunity for this week for 2 points added to your third exam by Sunday night, April 27. Do a little searching online for this issue. The PhD project, UAB has participated in the PhD project in the Collat School of Business, and it is now UAB being investigated by the Department of Education for doing so. Why is that the case? Why is it being investigated, and what does that have to do with the subject of illegal discrimination? Here's our calendar. Today is Monday the 21st. The next slew of things that are due are next week, but boy, a lot of material going to be covered. Look at the reflective memo that is going to be due on Monday the 28th. There's a survey that everyone has to do on the 29th. There are some CPA client simulations that are due on Wednesday the 30th. Third exam opens that same day and closes on Friday, May 2nd, which of course is the last day of school.